Hi, my name is Suzanne Kingston, and I'm here with my co-author, Edwin Alblas, and we are really excited to be speaking to you about our new paper, Magnetic Law, Designing Environmental Enforcement Laws to encourage us to go further. And that is just being published in Regulation and Governance. It's an open access and it's funded by the European Research Council. Really, the idea behind the paper is looking at this problem that we have in Europe, but in fact, it's a global problem of undercompliance with environmental law and how we might try to improve that undercompliance. And in Europe, it's a really great case in point because we have so much environmental law on the books, but under enforcement and under compliance is a huge issue, as we know from the declining biodiversity rates, for instance, in Europe, to take one example. So really the idea behind our paper is to look at the recent efforts on the part of the EU in conjunction with an international treaty known as the Aarhus Convention, to try and improve private environmental enforcement. So the whole idea behind the Aarhus Convention is to get citizens and ENGOs involved in enforcing environmental law and to improve compliance overall. And so in our paper, we are really investigating whether the Aarhus Convention has really been successful. What effect has it had on compliance decisions by regulated parties? The specific example we are looking at is the behavior of farmers in enforcing nature conservation rules in the EU. And so we're asking this question, has this so-called democratization of environmental enforcement in the EU really worked? Or how can we say there have been some examples, for instance, of crowding out of farmers' otherwise intrinsic pro-environmental motivation. So that's what we're looking at in the paper. And I'll hand over to Edwin to introduce the methodology.
Yeah, thanks, Suzanne. So in our paper, we've tried to adopt a 360 perspective, capturing the views of three key stakeholder groups. So the farmers as the regulated parties who have to deal and interact with these nature rules, and then citizens and ENGOs as the actors that might get involved in the enforcement of these rules. We've looked at 3 member states, Ireland, France, and the Netherlands, and we've carried out approximately 2,000 surveys, 165 in-depth interviews to get more granularity and in-depth findings on the survey findings. One of the key findings here that we saw was that despite this effort of implementing the Aarhus Convention, there's still a huge focus among all 3 groups in our 3 countries on the state as the main enforcer. We'll just see how this plays out in more detail. So starting with the farmers' perspectives on private enforcement, what we saw is that ENGOs are often really perceived as outsiders. Farmers don't want them to get involved in anything, but especially not in private enforcement. Usually there's a lot of distrust, and we talk about it in detail in our paper. What we did see is that there are cases where there is successful mutual dialogue, and that can actually be very effective and mutually beneficial. For farmers, it can be a great way to improve their social license to produce when they're working with ENGOs and implementing nature conservation efforts in their work. What we did see is that farmers are usually very opposed to citizens getting involved in private enforcement unless they actually live in the local proximity. So for instance, there's cases of citizens who got involved because there was a factory farm built next to their house, and then farmers usually think, okay, this makes sense, is justified. But if it's some sort of a city person getting involved, then there was a lot of opposition. The ENGO's perspectives on private enforcement were a bit mixed, but we saw that overall it's a very subset of ENGOs that are specialized in the use of Aarhus mechanisms. They're very focused on private enforcement, but that's only a subgroup. For most of them, it's very complex to use the Aarhus mechanisms of access to information, of public participation, and especially access to justice, so taking court cases. ENGOs felt it was also too difficult for citizens to get involved, And for that purpose, often when citizens wanted to start cases, for instance, there's this small set of ENGOs that are specialized in this that will help them, or that can help them in some cases. Again, we saw that overall it's mostly the state that ENGOs think should take the main role as enforcer, not them. But some of them, or at least the ones that have taken up a role as private enforcement, felt that they did this or had to do this because the state is not doing it. And there's a very little appetite among ENGOs to target farmers directly. Usually they would take cases against the state for not implementing laws, not abiding with environmental laws, etc. And to finish off with the empirical findings, some bits of our findings on citizens' perspectives. So what we saw is that across the 3 countries, citizens are usually quite well aware of Aarhus mechanisms, although they wouldn't always know the name of the Aarhus Convention. They would usually know these mechanisms exist. However, few citizens actually make use of these mechanisms, and especially access to justice is very little used in practice, mostly because of the time and the cost involved. So they're still not very accessible for citizens, these mechanisms.
So what policy lessons can we draw from this? And how has this regulatory experiment that we've had in terms of the Aarhus Convention really been working? Well, we found that, as Edwin has said, there is this still residual strong belief across all 3 jurisdictions and all 3 stakeholder groups in the central role of public enforcement by the state or the European Commission, despite the Aarhus Convention already being in place for decades now. So we found that enhancing environmental democracy will, we think, require a deeper shift in regulatory tradition, and for private environmental enforcement really to flourish in practice. It's going to take a supportive regulatory culture which is fostered by the state. And so use of the Aarhus mechanisms must be straightforward, it must be uncomplicated, and it must be cheap. And we also suggest that if the policy aim is truly that of enhancing environmental democracy, there may be perhaps more directly effective tools than the Aarhus Convention, in fact. And one such tool may be, for instance, encouraging consultative or deliberative citizens fora that might include environmental governance, for instance, such as has taken place in France or Ireland, for instance, that may get more citizens and more ENGOs involved than the Aarhus Convention mechanisms are currently achieving. We also found that, as Edwin has mentioned, in the absence of mutual dialogue between farmers and ENGOs, for instance, there can be significant distrust among some farmers' communities of some ENGOs. And so our findings do support the retention of certain legal standing rules that do require, as is normally the case at present, proof of some type of sufficient interest for individuals in order to be able to challenge a measure. And so they suggest that some kind of actio popularis, allowing everyone to standing to challenge an environmental measure, that may in fact be counterproductive in terms of crowding out farmers' intrinsic pro-environmental motivations that may otherwise exist. We also found proof of what Friedman has called this defiance effect, and this idea that where farmers don't buy into or don't understand the laws that are being imposed upon them, this can lead to positive wishes to defy the law, and those wishes may in fact be supported by the local community. And clearly this is not a good thing that policymakers will want to avoid. So clarity and consistency of the state's message also really matters. So when one arm of the state is saying one thing, let's say the nature conservation arm of the state is saying one thing, it is very important that another arm of the state is not saying something that conflicts in terms of messages. For instance, the agricultural ministry or department must be singing onto the same hymn sheet in terms of biodiversity and nature conservation rules. Otherwise, as I say, pro-environmental motivations may be crowded out. We found that private enforcement can result in a certain degree of polarization of communities. And it's very important to avoid a perception that farmers are being bullied, for instance, by private enforcers coming from the outside, such as ENGOs, which may, again, we found, deter them from otherwise pro-environmental actions that they may otherwise be minded to take. So our recommendations for regulators and policymakers are really simple and intuitive in many ways. Firstly, knowledge, communication and clarity of message is really critical here, not just of the content of the law, but also the environmental purpose of the law. And this supports the idea that there must be a clear and independent source of information that all stakeholders may consult on what the EU nature rules say and also what the Aarhus Convention mechanisms allow. We found the mode of communication really matters. For instance, farmers, we found, do not generally like to have to look at websites, and other means of communications may be more effective. And then finally, procedures, consultation and inclusivity really matter, we found. So we found the most successful examples of laws crowding in pro-environmental motivations were in cases where there were locally led conservation farming schemes that have regard to the specific features of the protected area at hand and have involved farmers in creating those rules. And these can really crowd in motivations. So thank you very much. We hope you enjoy reading the full paper, which, as I say, is open access. We would invite you also to look at our website, effectivenaturelaws.ie, for more information on our broader European Research Council project on environmental governance. Thank you.